Joining me now, Joyce Vance, former federal prosecutor, now law professor at University of Alabama, MSNBC legal analyst, and host of the Sisters-in-Law podcast. Good to see you, Joyce. Before we get to Justice Thomas, give me your interpretation of Judge Cannon's new deadlines today.
Well, Judge Cannon's new deadlines are precisely the kind of deadlines she always sets, ones that aren't real, ones that indulge every request by Trump for delay, no matter how unnecessary. And look, Alex, here there's a legitimate question. She does need to resolve the meaning of these rulings for this case, but that's not difficult. That's not something that requires setting everything much further out for the simple reason that the conduct alleged in the Florida case occurred after Trump left the presidency.
You know, by that description, Joyce, is there any question as to her bias and influence from Donald Trump and the way she's conducting herself in this court?
She certainly never hesitated to put her fingers on the scales of justice in his favor.
All right. So you wrote that the issue of Jack Smith's appointment, that was not part of the immunity case. So how did Justice Thomas get that into the ruling? And can Trump rely on it to get his charges dismissed?
Well, Justice Thomas wrote a concurrence on this issue. He makes the point that in his view, Jack Smith was improperly designated special counsel because the Attorney General didn't jump through the right hoops. And of course, this is a concurring opinion that no other justice signed off on. It does not have the force of law. Certainly, Judge Cannon could take note of it. She might even reference it in passing when she writes her opinion on this topic. But Trump filed his own motion in this regard months ago. The judge has already held oral argument. This is the issue where she took that unusual step of inviting amicus, lawyers who aren't parties in this case, to come in and help her make up her mind. So there's nothing new here that should influence the outcome of her decision.
Okay, but let me ask, because given this ruling, could Trump now say, look, I decided to keep government records while I was president and therefore can't be prosecuted for holding on to them? Or are there substantial bad acts after he left office that can still go to trial?
It's a real double-edged sword for Trump. You know, prosecutors didn't indict him with taking these items from the White House, presumably for the simple reason that they couldn't prove that. But what they could prove was his possession, his unlawful possession in Florida. And that's a continuing crime. So even if you could make some convoluted argument that when he took the documents out of the White House, he might have immunity for that, I think it's a terrible argument, but I'll spot it to you for the sake of argument. This ongoing crime of possession that occurs every day, day after day when he's not president, in a normal world, he wouldn't get immunity for that. Of course, we now live in a world where the Supreme Court has engaged in this very expansive definition of what constitutes public official conduct for a president. So there will be a ruling by Judge Cannon in Florida. It will go up to the courts of appeals. Look, this is the case that should go forward, but nothing is certain in this entire legal rubric that we're now dealing with.
Okay, so just to simplify, so you're implying that he might be able to take them or make the argument for that, but he can't keep them.
Exactly. Here's a great analogy. Firearm possession by someone who's prohibited from possessing a firearm. It's a continuing crime. You know, every day that you're doing it, it's still a crime again, right? So even if you could make an argument, and maybe this is a bad example, but say for those 10 days, he wasn't a felon or he wasn't an addict, so the possession was legal. But for these other 10 days, it was unlawful. Well, you could still charge that crime. Same with Trump. Even if when he originally took these documents, that was legal, I don't think it is. That ongoing possession and certainly the obstruction of justice, all of which occurs after he's left the White House, is conduct that he should stand trial for.
Okay. In Trump's D.C. January 6th case, Judge Chutkan is now required to parse which of Trump's actions were official and must be stricken from the case, and then which were unofficial acts that can proceed to trial. What kind of evidence do you think will now be off limits, Joyce?
Right. So there's two parts to this ruling by the Supreme Court. The part that says you can't charge official conduct and the part that says you can't use evidence that constitutes official conduct. And in some ways, that part may trouble prosecutors more. You'll remember that Jack Smith, in his brief to the court, had said, by the way, even if you dismiss some of my charges because they're official conduct, I can still use this evidence, and you should greenlight that. And the Supreme Court said, not so fast. We're not going to give you the green light on using that evidence. And so now Judge Chutkan will have to look at the indictment. There will be argument from the parties. It's likely that she may want to hear from some of the witnesses to make these fine line distinctions between what's official conduct, core conduct that the Constitution requires only the president to undertake, what's in this much more amorphous bucket of conduct that would be public conduct, official conduct by a president, but perhaps in an area of shared responsibility with Congress or others, where the judge has to decide whether that presumptive immunity will stay in place. And then, of course, she might find that some of this conduct is personal conduct, conduct that I would have described before we saw this opinion as conduct committed by candidate Trump, not in his official capacity. But the court certainly has created a lot of wiggle room. So she'll have to distinguish between all of those, and then the Supreme Court gets another crack at it to say whether they believe she got it right or not.
Last question here. Are you surprised at all by the Washington Post report that DOJ plans to move ahead with all the federal cases up to as late as Inauguration Day, next January 20, if the election were to break for Trump? And do you see the January 6th case getting to trial before then?
So I think a lot of that depends on how quickly Judge Chutkan gets to work and whether or not the Supreme Court expedites the appeal that follows from her decision. It would be a heavy lift to get there. It's absolutely the right thing for the Justice Department to continue to do its job until it can no longer do it. That's what we would do in any other case. You know, your obligation is to pursue the facts and the law to their logical conclusion, and that means continuing to move towards trial.
Okay, Joyce Vance.
Hey there, MSNBC fans. I'm Luke Russert, and be sure to join me, Rachel Maddow, Jen Psaki, Lawrence O'Donnell, Steve Kornacki, Joy Reid, and many more September 7th in Brooklyn, MSNBC Live Democracy 2024. Click on the link for ticket information. We will see you there.